Adjournment request, if any, from item number 1 to 9. From item number 10 to 20.
Wait, please, my lord. I'd like to mention item number 17, my lord. There's been a change of councils. My lord, we require some time. Right.
May I please, sir, to consider the other party, I'd like to mention item number 19, my lordship.
19.
Yes, my lordship. I'm applying for respondent 2 and 5. We need 2 weeks time to take the instruction, my lordship.
You have heard that?
Respondent number 2 and 5 for PW.
You were supposed to.
We need some time, my lordship, for take the instruction, my lordship.
Last time, that's why only the matter was adjourned. It's a hearing matter now. After a week. Not
Yes, my
more.
lordship.
May I please, Lordship?
In all the matters where the adjournment slip is circulated, matters will be adjourned.
Lordship.
Is item number 11, 12, 13, 15, 17, 20. All matters are adjourned.
Lordship, in regard to item number 14, Lordship.
Yeah,
Item number 14, Lordship.
14, yeah.
Lordship, the conducting council, Mr. A.R. Guay is under treatment, Lordship, and he's out of station, Lordship. So, Lordship, can you kindly pass over the matter for the.
Aभी 10 days.
Lordship's permission, item number 3, we have filed an affidavit and they will call for me. Item number 3.
We'll call.
Repeat your lordship. Lordship, I beg to mention item number 22 with the consent of the other side, I pay for adjournment for
Item number
22
22.
and
Yeah.
for respondent 1. So with the consent of the other side, I pay for adjournment for today. Lordship, conducting
Electricity. Oh, but this is being temporary occupation.
and this council has gone to his native place Bihar for the treatment of his age-old grandmother. So kindly adjourn and fix a date the last week of November.
Adjourned.
Advice.
May I please, your lordship, with the consent of other side, I beg to mention item number 23.
Yes.
It may be,
Serious doubt about maintainability. You have not challenged the order passed by the London single judge, you have challenged the review order. How can it be?
your lordship, it may become along with writ appeal 5/2024,
Why?
similar matter. After,
How it is similar? How it is similar?
my sin-
Let the number constituency.
Any other request? Supplementary list, item 25 for orders.
Yes.
I've said, just received, me say is hereby instructed to take necessary steps for giving consequential benefits as per the order of the Honorable Guwahati High Court. Further, Director of Elementary Assam is also instructed to ensure that the period without duty shall not be considered as break in service, and the said period shall be counted for the purpose of service benefit, including retirement benefit. Well, Ashwin, just keep it pending for If there is no, because again, he has instructed, if it's
So
subordinate,
he is instructed, then certainly he has to be. applied.
but if it doesn't follow, then we'll apprise this honorable.
It's altogether different.
Yes.
Okay.
Today I'm filing the affidavit also, madam. I have already,
File an affidavit.
yes, madam.
File an affidavit and then we'll.
Yes,
make an
madam.
affidavit
Once it
from
is,
the court and then we'll pass an order.
Inform the court martial.
We'll pass an order.
Yes, madam. Obliged.
File it immediately.
Yes, madam.
File to LA.
For the time being. So,
For hearing, item 1 and 2.
Pastor, for the time being, madam, Leonard AG would be addressing. For the time being, madam, he's.
like, Leonard Eddy was supposed to.
Yes, madam, he's here, he's prepared. Just gone on, madam. After some time, madam.
Pass over the time.
Item 3 to 9.
What affidavit you have filed?
Madam, we have filed that it will, we have not,
It's
copy is not here. Otherwise, my lord, we state that we stick to the rules, my lord, we'll defend the rules. Is the
In the rules, this vice principal, how you can, what the vice principal without having been simply saying that since they are deprived from the promotion, this can't be a ground.
My lord, if lordship would kindly have, my lord, two documents I had given on the other day. I'm not saying that, my lord, will. But this- but-
You have a copy of the affidavit you have filed?
Yes, my lord.
Now, you have withdrawn that letter now, 2021.
No, it
What
will
is
be,
the basis for that?
my lord, when that letter was issued, this is a rule under 309, my lord, by the governor. The secretary simply writes to, worship will find there were three letters given in the original affidavit by the petitioners. One of them stated,
Hey, affidavit of fact.
yes.
Maybe we. Same language. But then that would be informing that as there is no provision from consent of contact. And the department will speak to the existing proposal, which came into force with the amendment. So they were saying that make the. In continuation, the circumstances, the views of the shall stand until further review. Hereby reform and within the case of the 276. 246.
Why this change of heart?
My lord,
What is
Lordship,
the reason for that?
Lordship will see at the,
It's a reasoned order. It is still the BA is compulsory post of so and so graduate teacher and so for the promotion headmaster for vice president government higher secondary school, BA should also be made compulsory for promotion to the school. Therefore, they are requested to recall the affidavit filed on behalf of the High Court. New affidavit in this area is the full name.
Lordship will kindly have the next letter, my lord, on the next page, 247.
Yeah,
With reference to the above, and directly say the education department is preparing a new service as per the new education policy and BA degree shall be made compulsory. That amendments have come, my lord. The amendment did not include this.
BA degree shall be for the vice principal.
Yes,
Where
that,
is that amendment?
those amendments have come. There was no change in the vice principal thing, my lord. It was not considered.
Why not?
Now, my lord, I'll just point out, Lordship, give me just 2 minutes. It can go either way. I'm not fighting for
We are
anybody, my
hearing
lord.
you,
Just-
sir. What do you mean by 2 minutes? We are hearing you. Take your own time.
My lord, I had given a judgment, all Assam Higher Secondary Teachers Employees Association, for a moment, Lordship.
Yes, we can, sir.
The judgment will come later on. The reason for you just.
Judgment, that is what I'm trying to show, how this to 2003, we had it 2018, why did not? That is what I'm trying to just show. And here, my lord, when we had made the the BA degree compulsory for the principals, there was a challenge to that portion of the rule, that it should not be made compulsory for the post of principal also.
Fine.
And here, Lordship will kindly have paragraph 3 of the judgment.
Judgment.
On the last occasion, I had given over the.
Last occasion of last-
I'm sorry, I'll-
Name?
All Assam Higher Secondary teachers and employees.
Disciplinary.
Supply us copies. The.
Lordship, see the paragraph 3. According to the petitioners, the requirement of BA degree is arbitrary.
That is the, according, yeah.
Paragraph number 3. According to the petitioners, the requirement of BA degree is arbitrary and irrational for the category of postgraduate teachers or vice principals recruited out of the postgraduate teacher. As for recruitment to the post of postgraduate teacher, neither at the time of entry into service BA degree is required, nor thereafter they have opportunity to get BA degree. For the first time, this requirement has been provided in the amended rules for the recruitment of post of postgraduate teachers, and by notification dated 13 September 2012, this recruitment has been relaxed up to 1st of January 15. This being the position, postgraduate teachers or vice principals appointed out of the postgraduate teachers will stand disqualified when we considered for the post of principal, resulting in denial of level playing field without any valid justification. In para 11 of the writ petition, it has been averred. Now, Lordship would come to para 5. We have heard the learned counsel for the parties. Learned counsel for the state says that since the matter is legal, it was not necessary to file reply on due consideration. The state has issued notification dated 13 September 2012, granting relaxation in requirement of having BTBA up to 1st of January 2015 for appointment in higher secondary school, high school, Muhammad Raza, subject to the condition that the candidate will have to acquire BTBA degree within 5 years from the date of joining. However, he has no instruction on the issue of qualification of BTBA degree for postgraduate teacher for eligibility for the post of principal. On due consideration, we find merit in the grievance of the petitioners. It is clear that the amendment of qualifications required for recruitment to the post of principal in clause 11(1) of the postgraduate teachers or vice principals. No such qualification was laid down at the time of entry into service nor at any point thereafter. They could obtain such degree. Thus, eligible candidates with 15 years service will be rendered ineligible, which is arbitrary and discriminatory. Graduate teachers being allowed to acquire this qualification during service, which postgraduate teachers were not, and therefore postgraduate teachers could not be treated at par with graduate teachers in the matter of having BTBA degree. In view of the above, the rule may either require to be set aside or may have to be reconsidered by the rulemaking authority. Accordingly, we direct that the issue may be reconsidered and finalized within 2 months from the date of receipt of a copy of this order, and pending such finalization, no further regular promotion be made to the post of principal in higher secondary multipurpose school. Any step taken pursuant of the above may be reviewed in the light of the above directions. So,
ridiculous, you know? We are the leading for years, our breaking the reason was that after the we have at this but if we that 15 then but today that is not has been here all over.
Now, what is the qualification for appointment of now this postgraduate teacher?
Postgraduate teacher, my lord, they need a postgraduate degree and
In
the BA.
2018,
My lord,
in 2000,
they need a BA.
they need a BA.
They need a
In
BA.
2012, they don't need any BA.
No, they in
They didn't need, but there was no provision for BA, having BA qualification.
my lord, prior to 2012, no one needed a BA.
Yeah,
No one needed a BA who was appointed prior to 2012. So now vice principal is a post where the seniority counts. So people who were appointed prior,
the premise on which this order was passed, that on due condition of grievance, it is clear that the amendment of qualification required in the post of so and so, so and so. No such qualification are laid down at the time of entry into service, nor at any point they could obtain such degree.
exactly, my lord. The persons who were appointed prior to these were persons who were appointed prior to 2012. Even in this particular case, those persons for whom we are saying that BTPA will not be necessary, those will be the persons who were appointed prior to 2012.
What is the bifurcation?
My lord, in the rules.
Yeah.
My lord,
There is
those-
that, only those persons would be promoted
Huh.
on the post of vice principal who were appointed prior to.
Because
2012.
after 2012, automatically everybody has BA. People could not have been appointed after that. After 2012 phase, this worship.
Graduate with at least 50% mark, no, permanent university and BA education from national computer or government. So आपने approach है कि the recruitment condition will be a major model.
Yeah. Yeah. এক নম্বর মেটা প্রসেসের বেরিয়ে আসছে সব মোবাইল আপনি এখানে একটু কিছু মুখ দিয়ে থাকি তারাই কি বুঝবে রাতেরা
Oh, हाँ, वो भी नहीं करेंगे.
প্রমোশনের ক্ষেত্ৰত আছে যদি প্রমোশনের ক্ষেত্ৰত লাগে
13.
এই প্রমোশন You have not provided, isn't that? Cannot be envious.
A graduate teacher we follow this principle
Same then.
because one does not to graduate teacher उसी में भी हो उनका भी BSc में वो भी eligible हो जाता है. So ये decision is only with regard to postgraduate teachers, but we graduate teachers is also.
Yes.
So, my lord, If Lordship finds that it is discriminatory, I have nothing to say, but otherwise, but our only choice was that the persons who were
It's mandatory, sir. It is in addition of the, not discriminatory, mandatory.
the
When the entry level post requires, at the time of entry, a person is required to be BA. But so far as regarding post of vice principal is concerned, is not required.
entry level for persons post 2012 is the only criteria if Lordship finds it.
Challenges to Rule 13. Your case that you have produced, that case law of this court, is pertaining to postgraduate teachers.
Postgraduate teachers.
Yes, it's
who
only
would-
specific who could not pursue.
Who could not go to the post of principal because we had made BTB and
Okay, fine. So now today you mean to say those postgraduate teachers have to be protected because they did not have a scope to go for that B.Ed degree.
And therefore we give it to the post of vice principal.
Vice principal, but the Rule 13 also brings within the feeder cadre the post of graduate teacher.
Yes,
Then where is that distinction that for graduate you will have to have
even
a,
for graduate,
a B.Ed degree and for
For-
postgraduate that is,
for both graduate and postgraduate teachers, graduate teachers need to have a certain amount
if
of
we,
experience.
if we go by this decision, graduate teachers had the liberty to go for B.Ed degree. The basis of this decision that you have relied is that postgraduate teachers were not being permitted to go for
Yes.
B.Ed degree. That was not the case with graduate degrees. Then how do you support the inclusion of graduate teachers here?
Those graduate teachers must also have a particular length of service.
That is
All
there for principal also.
All graduate teachers.
That is there for principal also.
No, no, no. The
17 and 15.
The graduate teachers need a particular length of experience, and even graduate teachers who were appointed prior to 2012 were not required to have BA.
Fine.
So this clause protects both the postgraduate and the graduate teachers who could not obtain BA degree.
And another
If we are
thing.
wrong, then
Not obtain,
No,
there's
graduate
difficulty.
teachers are always having opportunity to obtain this graduate
That-
BA degree.
That
That
opportunity.
is what this judgment says.
That opportunity, because the judgment did not quote everything that was in the repetition, but that opportunity is given to graduate teachers on a seniority basis. Many graduate teachers did not even have that opportunity also. So those teachers who did not have the BA degree and are senior, those teachers who could not get the BA degree but were senior to the petitioners, perhaps their teachers.
Okay,
We
why
need to
did you,
protect them.
this court had clearly said postgraduate teachers were deprived. Let's, the essence of this judgment, postgraduate teachers were deprived from holding the post of principal because they did not have a B.Ed degree. Why did you incorporate that in the rules then? Why did you not make a separate class for them? For the postgraduate teachers without B.Ed
The
degree
wisdom of the
before 2012? This is not
That
the
was
wisdom
not
of
an
the
issue that
legislature.
was
This is
taken-
your departmental wisdom.
That was not a issue before we placed before the department because it did not fall earlier from today. What we were trying to
This analogy,
Yes,
then
so those postgraduate teachers are being protected only to the post, because when the law also says that we are the persons who will determine what is the qualification that is required to be for a
and this.
particular post.
absolutely
We do
now
it proper.
this, whatever the letter of this additional secretary of 2021, you have withdrawn this letter on 4/11/2024.
Because I have given the second letter which says that it will be incorporated even in the rules, in the new amendment rules.
And you have
Those-
not,
it did not incorporate. It did not incorporate.
Secretary, हम rule follow करेंगे. Point. Number two. Four eleven यहाँ पे नहीं है. वो इसमें नहीं भी है. Number 25121474. नहीं, ये in 2021. Component. ठीक है सर, वो withdraw किया है. As soon as letter has withdrawn its earlier communication dated 30/10/2021. ये 30/10/2021 was withdrawn by 4/11/2024. That is not possible. ये 5/11. ये है 23 का. ये है 7/8/23. Reference number 1. Yes, one meter. And reference number 2 is 4/11/2024. जो यहाँ आता है, ये इसका कॉपी यहाँ नहीं है. तो इस दिन को उन्होंने वो विड्रॉ किया, फिर जाकर दूसरा इशू किया था. तो उनको तो ये नहीं, हमें नहीं दिया. Where is that? You come to your page 251 of the affidavit.
That one belongs to me. Yes, madam.
Second paragraph. As such, letter reference number 2 above department has withdrawn its earlier communication dated 30/10/2021.
Yes.
So that 4/11 is not a part of the records. 11/2024 is not part of the records
Of this one, madam.
of the affidavit. It's not there.
Right.
And this page 240
411 was a direct communication to me saying that.
249.
249 years.
This also does not refer to 2021.
Yes, it was when I
So-
asked them whether.
No,
this-
no, no, no.
Whether you support it or
That
not.
decision that is there in 2021 is a decision he is communicating that I am directed. So there is a government decision. And this decision, if it is in review of that,
May I put it this way? Either I bring all the records. to
that's
justify
what we
these
permitted
letters.
you last time.
But that is the letters which are relevant, which I found relevant with place of lordship, if lordship finds the rule to be. Little I can do.
It's a government decision. When you have- If this letter of 23 is in review of that, and this is a letter to the. It's also a letter to the standing council. Don't want it. ये देखिए सर 248 248. ये सर रात को भी गया था. आपने जो बोला था नहीं बना दी. आपने जो आपने जो बोला
Yes. My lord, I'll rely upon one judgment of the Supreme Court and one division bench judgment of this honorable court, which has cleansed the issue already, my lord. In fact, if your lordship would kindly have 2026 GLR page 1. GL, oh my God.
in years. 842.
My lord will kindly come to para 14. whether the paragraphs will tally Right to Education Act 2009,
Para 10.
para 10, my lord. The Right to Education Act was brought in by the Government of India. I am holding actually GLR.
Para 14.
Yes,
Here is para 14.
yes. The Right to Education Act 2009 was brought in by Government of India, making education compulsory for children up to 14 years. By this statute, a sea change has been brought about in the field of education from primary to secondary level by bringing in several requirements and parameters which are to be maintained by the state in respect of the school management authorities, as well as qualifications desired from the teachers seeking employment as such. As per the provisions of the Act, qualification and terms and conditions of service of teachers are to be laid down by academic authority as authorized in this regard by the central government. Much prior to the enactment of the RT Act, the central government had established a council to be called National Council for Teachers Education under National Council for Teachers Education Act 1993. The Constitution, the power, the functions of the National Council for Teachers Education are provided for under the said Act of 1993. After enactment of the RT Act, the central government by notification dated 31st of March 2010 was established, which was published in the Gazette of India on 5th of April 2010, notify the National Council for Teachers Education to be the academic authority to lay down the minimum qualification for being eligible for appointment as a teacher, as also the curriculum and evaluation procedure. Thereafter, NCT by notification from time to time laid down minimum qualification for a person to be eligible for appointment as teacher, etc., etc. So it is the academic authority. Now, Milord will kindly come to para 36, Milord. So the academic standard would be laid down by, my lord, the academic authority, para 36. Para 36, Milord. The sentence starting with the accrual of any right. The accrual of any right of any candidate towards selection and appointment to any post under the government will have to be determined, keeping in view the parameters laid down in the service rule governing such recruitment. In view of the provisions of NCT Act, the RT Act, all notifications issued by NCT will have to give an primacy in arena of qualification laid down for teachers and the process of selection of such teachers. The Supreme Court in the recent case relating to prescription of qualification for recruitment of teachers by state government held that state government was under an obligation to act as per the notification issued by NCT and not to give effect to any contrary rule. The Supreme Court in this case had the occasion to deal with inter alia notification dated 23/10/2010 issued by NCT, which is also the relevant for the present proceeding. The question which arose in this case is that as the central government under section 23 of the RT Act has given power to lay down the eligibility condition for appointment of teachers for elementary education, whether NCT could not lay down any guideline so as to affect the power of a state to prescribe norms for selection of teachers consistent with qualifications under section 23 of the RT Act. Supreme Court held that the state government was under an obligation to act as per the state or notification and to not to give effect to any contrary rule. The relevant paragraphs of the judgment in 2018-12 basis is extracted below. We have heard the learned counsel for the parties. Main contention raised on behalf of the state of Uttar Pradesh is that while it was permissible for the central government to lay down eligibility qualification for appointment of a teacher for elementary education by virtue of section 23 of the RT Act, the NCTE could not lay down any guideline so as to affect the power of the state to prescribe norms for selection of teachers consistent with the qualifications under section 23 of the RT Act. On the other hand, the stand of the original petitioner is that the subject of education falls under Schedule 7, List 3, Entry 25 of the Constitution after the 42nd Amendment. Thus, by virtue of Article 254 of the Constitution, the law made by the Parliament prevails over any law made by the state. It was submitted that NCT Act has been enacted by Parliament to achieve a planned and coordinated development of teachers' education system. The council constituted under the Act is empowered to issue guidelines under Section 12 and 12A for ensuring planned and coordinated development of teachers' education, and also to lay down guidelines in respect of minimum qualification for a person to be employed as a teacher. Further, by notification dated 31/3/2010 under Section 23 of the RT Act, central government has authorized NCT is there as the academic authority to lay down the minimum qualification for persons to be eligible for appointment as a teacher. The Learned Council for NCT submitted that notification dated 11/2/2011 suggesting weightage to TET marks was merely a guideline and was not intended to bind the state. While TET was a mandatory requirement, weightage to the TET mark in TET was merely a suggestion. This stand has also been taken by some of the Learned Council in connected matters. Reliance was placed on stand in so and so. That in view of the said recommendation of the committee, it is stated that guidelines contained in clause 10 and 11 of the NCT guidelines are directed in nature to the extent of, my lord, weightage. Appropriate government may in its own
That side, that the NCT guidelines have to be
followed by the state.
Yeah. So what is your argument on that way?
Because our argument is very simple. When the feeder category post requires, my lord, B.Ed,
Particular qualification.
particular qualification, is it conceivable in the normal scheme of things that for the promotional post it would not be required? And we see, my lord, in the process, what prejudice is being caused to the petitioners. The senior ones, they will become vice principal. Junior ones like us will never become vice principal because by the time they retire, we'll also retire. As a result, what happens, my lord? People with qualification, having qualification even from the junior person also now come up. Now the issue is very simple, my lord. When you have prescribed B.Ed for feeder cadre, how can you say that no, will not prescribe, I will not insist on B.Ed for a promotional post? Well, it's an anomalous situation, my lord. A lot of incongruity has crept in the entire scheme of things. Now, this is, my lord, para 17 is very important, my lord, of the Supreme Court judgment, which is quoted here at face para 17 of the Supreme Court judgment, which is quoted. There is no manner of doubt.
Quoted in
Para 17, my lord.
36.
Yes. There is no manner of doubt that NCT acting as an academic authority under Section 23 of the RT Act, under notification dated issued by the central government, as well as Section 12 and 12 of the NCT Act, was competent to issue notification dated 23/8/2010 and 11/2/21. Now, this is the state government was under an obligation to act as per the said notification and not to give effect to any contrary rule. However, since the NCT itself has taken a stand that notification dated 11/2/21 with regard to weightage to be given to the marks obtaining is not mandatory, which is also a possible interpretation. View of the High Court in what had happened, my lord, in respect of notification dated 11/2/21, the stand of the NCT before the Supreme Court was that weightage to be given, it could be given, could not be given. It was construed to be directory in view of the stand taken by the NCT. But otherwise, as an academic authority, when NCT lays down certain norms or standards, state government is bound to follow it. There is no question of lowering or enhancing the standard which is set by NCT. It is a misnomer to say that we can't go down, but we can go up. There's nothing like it, my lord. Because it is the Constitution felt, my lord, the academic.
That judgment, there are some judgments of the Supreme Court which says that minimum qualification can be prescribed, but the higher qualification for a particular that is also permissible. It should not be less than minimum qualification.
No, my lord. Yes, should not be less than. Now here less than is B.Ed. Minimum is B.Ed. So how can that dispense with B.Ed, my lord? My lord, does it stand to any logic? I don't think, my lord, here is a case which, poses an insurmountable difficulty. The simple matter, my lord, once uniformity is there, then there will be no. Mhm. अस्सी लगा था। Now, if your lordship would kindly have para
Sir,
37,
one second.
sorry. My lord, may kindly come to para 37, my lord.
Yeah.
In view of the law laid down by the Supreme Court as above, the notification dated 29/7/11, laying down the essential minimum qualification for seeking employment as lower upper primary teacher will have to be given primacy. On a plain reading, it is clear that advertisement dated 16th of July 14 had deviated from the qualification laid down in notification dated so and so issued by the NCT, inasmuch as the advertisement dated 16/7/14 under the essential qualification and experience, the graduate degree from UGC recognized university with TET elementary pass was also provided as alternative criteria. However, the same is at variance with the criteria provided for by the notification dated 27/9/7/11 issued by NCT. As per the said notification, candidate must have graduation and 2-year diploma in elementary education. As stated above, it is not mere graduation along with TET which will make the petitioner eligible to enable them to stake any claim for any vested or accrued right. Petitioners have not stated anywhere in the pleadings that they have acquired 2-year diploma in elementary education and thereby making them eligible as per notification dated 29/7/11. The petitioners have insisted upon only TET qualification besides being graduates. Under the circumstances, besides not having 50% in their higher secondary, they also do not have 2-year diploma in elementary education as required under the NCT. As such, their contention that they're eligible as per the notification dated is incorrect on the facts and circumstances and disputes. So here, my lord, what was prescribed was 2-year diploma in elementary education, which they did not have. They have TET.
No, we don't. I'm really not doing it. No, no, because
Milord will kindly have the NCT's affidavit, Milord. National Council for Teacher, they have filed affidavit in this case. Page 204, Milord.
you believe that. Oh, yes.
204.
Yes, it starts at 200, my lord.
Yeah.
Para 5, that your humble deponent begs to state that NCT under section 32 read with 12A of the NCT Act issued another two notification on 23/8/10 and 12/11/14.
No, that is the latest. This is not para 5.
Affidavit in
That your
WPC.
humble deponent begs to state. Huh? Oh, sorry, Millard, 8682 of 2019. Item number one.
Page one.
Mark Facebook नहीं है।
It's there.
पेज पे भूल के लिखी है पेज पे भूल के
Yes.
Has your lawsuit got it? Yes. That your humble deponent begs to state that NCT under section 32, read with section 12A of the NCT Act, issued another two notification on 23/8/10 and 12/11/14 by modifying the earlier notification dated 3/9/2001, which notified National Council for Teachers Education determination of minimum qualification for recruitment of teachers in school regulation 2001. It further notified that the mandatory qualification as B.Ed degree for recruitment of teachers in any higher secondary school. Thereafter, the notification dated 12/11/2014 also prescribed the qualification for recruitment teachers in B.Ed degree from any recognized institution from NCTE, and in case of primary, upper primary from class 1 to 7, certificate diploma in nursery school, teachers education, preschool education, early school education program of duration of not less than 2 years, or B.Ed nursery from National Council for Teachers Education recognized. That your humble deponent begs to state that notification dated 12/11/2014 issued by NCTE with an object to bring uniform standard of teachers throughout the nation. The said notification is issued in exercise of the statutory power vested to NCT under NCT Act. Therefore, it is clear that the notification dated issued by NCT has got a statutory force and same is a part of the delegated legislation of the central legislature. That your humble deponent begs to state that post of assistant headmaster of a school is the next higher post to the post of headmaster. Similarly, the post of principal is the next higher post to the vice principal of a higher secondary school. All posts of principal headmaster mandatorily require B.Ed degree as essential qualification for either promotion or for direct recruitment, except for the post of assistant headmaster of the high school. NCT has also prescribed B.Ed degree as essential for the post like PGT, PGT of higher secondary school by NCT notification issued from time to time. But the impune service rule of 2018 does not include B.Ed an essential qualification post like so and so, so and so. But impune rule does not include B.Ed as an essential qualification for the post of assistant headmaster. As B.Ed is an essential qualification for the post of headmaster, principal, higher secondary school, this rule may also be applied to the post of assistant headmaster, as also government authorities ought to have included B.Ed an essential qualification for the post of assistant headmaster. So the NCT's stand is absolutely clear, my lord. They in fact say that for the post of, they are referring to assistant headmaster, or for the vice principal also, my lord. By analogy, the same principle will apply. Connection road, okay.
195 में शुरू हुई।
देखा जी बता दे।
यहाँ पे है these regulation may be called for determination of qualification persons recruited with censure in pre-primary, primary, upper primary, secondary, senior secondary, intermediate colleges. Regulation 2014 यहाँ पे secondary school page 196 graduate, postgraduate from university with 50 marks in the exact graduation, bachelor education and bachelor of education degree from National Council. This is in 2014. This was not.
Other way, promotion of the higher rate of respect. Oh,
What? So,
my lord, Finally, my lord, there are two aspects, perhaps in my humble submission, my lord, will fall for consideration. Apart from what we have already argued. Now, my lord, when we say repugnancy, what does it mean? Does it mean, my lord, that only, lowering the thing will amount to repugnancy, hiring will not? It's nothing like that. When a prescription by the state, qua the prescription by the union is in variance, my lord, then it itself is a case of repugnancy. In which case, my lord, Article 254 will be attracted. Now, my lord, coming to the second point,
Don't need to go and do all this.
second point, my lord.
This-
Now, my lord, my learned friend relied upon Contempt doctor's case. Huh? Corona nahi? Or Nath. Contempt Nath's case. My lord, if your lordship kindly comes to para 15 of the judgment, 15 and 16 of Contempt Nath's case.
He has not relied on, he
Oh.
relied on this all Assam higher
No,
secondary.
here it says, my lord, para 16, a requirement of BT BA degree in the context of school education cannot be held to be irrational. Contempt Nath.
He has not relied on that.
Oh, but we are relying, my lord.
He has relied on this all Assam senior higher secondary teachers employees association.
Lordship knows in some of the judgments, Supreme Court has said, supposing, my lord, at the entry level, some prescriptions were prescribed. Supposing there was a time, my lord, graduation was not prescribed for many posts. Subsequently, nowadays, of course, now, while for earning promotion from that post, if a higher qualification is prescribed, Supreme Court says it is permissible. Because higher qualification for promotion to a higher post forms a basis for classification, but not the vice versa. So that we, in that view of the matter, in my humble submission, my lord, it's an open and shut case. Where state authority has no option but to include, my lords, the prescription of B.Ed for all the category of posts.
Mr. Majumdar. The affidavit filed by the MC
My lord.
clearly says that for the entry level when the BEd is there, for the purpose of vice, principal of vice, for the purpose of promotion on the post of this vice principal, it must be there. Now come to this 195. Page number 195. That is this 194, 195, yes. The regulations may be called for national teacher education, determination of minimum qualification for persons to be recruited as education teachers.
You have it.
You have-
Mr. Alam, give him that affidavit.
Yes, we say.
2014 regulations. Now here it says. They shall have this 2014 regulation, now come to page 196. This minimum academic and professional qualification for the different courses prescribed here in the last senior higher secondary high school slash high school for ninth and 10th. Graduate, postgraduate from recognized university with least at least 50% mark in either graduation or post-graduation or its equivalent, and Bachelor of Education from NCET.
Yes.
Recognized institution.
What I was trying to impress is, I may be wrong, I will be, but what I was trying to impress is, there are two classes of teachers which we are dealing with. One class of teacher who were appointed prior to these mandates coming into force.
You just show us from the rule. Show us from the rule. It is open for all.
That is what I'm trying to come. I'll come to-
Postgraduate and graduate
I'll come
teachers.
to it, madam. Lordship will allow it. There were two classes of teachers before us. One who were appointed prior to 2012, one who were appointed after 2012. Persons who were appointed after 2012 could not be appointed without a B.Ed degree, meaning they mandatorily all carry a B.Ed degree with them when they come into service. Those persons who were appointed prior to 2012 did not have the B.Ed degree. Now, what I'm trying to explain, Lordship have the order that 5th of April 2022 in this petition.
2018 rules in copy paste here. 50% a month. And actually supposed to be-
Now, Lordships kindly have the order dated 5/4/2022 passed in this petition when this stay order was vacated. That is my last explanation, my lord, which I'm trying to.
5/4/22.
5/4/22, my lord.
Agreed.
Lordships will have, there was a quoted part of the interim order and just below that. In the counter affidavit. Lordship. In the counter affidavit, the state has admitted the position that under the 2018 rules, the qualification of B.Ed degree is mandatory qualification to hold the post of assistant teacher. Consequently, it is also mandatory condition for anyone who have later become the principal of the school or the headmaster of the school, as the case may be, principal for a higher censure. They could then argue that this exception has been created in case of vice principal for the reason that these schools are actually provincialized schools, which were earlier functioning as venture schools. The teachers therein were not having B.Ed qualification, and till 2012 recruitment was being made as assistant teacher, even though those candidates were not having B.Ed degree. Now such teachers are on the verge of retirement and the senior most teachers of the school, but they cannot become principal or headmaster of the school since they do not have the B.Ed qualification. Therefore, considering the fact that those teachers, being the senior most teachers of the school and are on the verge of retirement, are given the post of vice principal or assistant headmaster, they are allowed to copy. That is the logic of this state, my lord, right?
Yes, sir. We make it clear that matter has to be looked into. But considering the fact that-
Because requiring everybody to have a B.Ed.
Is your argument, the court has noted and simply said prima facie that this contention of the state.
What
appears to be
I'm not saying that
We
I'm
make
not-
it clear that the matter has to be looked into,
I am not.
but considering the fact that because of the.
If that argument was accepted totally on that day, the matter would have been disposed of on that day. It required further consideration. What I am trying to bring before Lordship is there are two classes of teachers. Making B.Ed equal, required for everybody would be equating them, which is against Article 2, Article 14, my lord. One equal places requiring to have equal.
Yes.
I'm for density, my lord, and basically is in fact, my lord, required for the either in the direct appointment or the promotion by
So the B.Ed is necessary.
my lord. And we have also annexed all the regulations, my lord.
What is that?
Deep.
Print out.
Obliged.
Print out exam. Hey, one second. Yeah, print out big leaf. And you school with them.
In item number 6, the petitioner number 1 has already retired. And the petitioner number 2 is also going to retire next year.
So what is
I adopt the argument of the learned senior counsel also. But I should be given preference of the ticket because I was deprived from the post of principal and there are few litigations
difference?
for the post of vice principal also. I also aspire for the post of vice principal in my school also.
Consequential release. One is retired and another is going to retire.
Retired also. And also one aspect also in paragraph, in their affidavit at page 169, they have mentioned one notification of 7/7/2014, that notification was interfered by the honorable court also. I had put to challenge that. May I place this note?
7/7/2014.
Notification.
Affidavit of fact. 8862. Affidavit 8862.
More, I think. 6.
What happened to final order?
Lordship, finally, Lordship subsequently they issued another notification, which I have annexed in my writ petition. All the notifications are annexed in my writ petition, item number 6. Subsequently, they also issued one notification, 18/3/5/11/2014 and 18/3/2015. I can also place it over.
What are those notifications?
In my writ petition also, I have annexed those. 5/11/2014 notification is in my writ petition,
Page.
page 36.
इस गवर्नमेंट ने 2015 में नोटिफिकेशन निकाल के बोला कि नहीं प्रिंसिपल के लिए हम लीगल वो जो रिलैक्सेशन दिया था उसको इसको खारिज कर दो।
For hearing item 10.
गवर्नमेंट की कोई डिपार्टमेंट Then there is two photo inquiry, photo inquiry 2 and photo inquiry 3. Photo inquiry number 1. But then then they in 2018 they issued a this was one thing. Calcutta ने बोला disclosure. This disclosure में then the matter उन्होंने business इनको मिला then we go because I don't know only on the gravity only on the it means that it's not a case that we are very continue.
Yeah, Lordship, may please, Lordship. Lordship, this ratification is directed against the order of the land tribunal by which the tribunal set aside the charge sheet and the department of proceeding solely on the ground of delay, Lordship.
The order of the tribunal?
200.
The tribunal set aside the charge memo and the departmental proceeding solely on the ground of delay.
What is that?
Lordship. Order is at page 208, Lordship.
Yes.
And the finding, Lordship, find at page 218, paragraph number 12. The issue was serious, Lordship. As an assistant garrison engineer, he is looking after the project. 2008 is the impugned order.
No,
218.
218.
218, paragraph number 12.
Yeah.
Onwards finding, Lordship. The issue before us to whether memorandum of charge dated so-and-so issued by the disciplinary authority is sustainable on the issue of delay in proceeding initiated against the applicant. The disciplinary authority issued thus said memorandum of charge dated so-and-so leveling 5 article. Now, if your Lordship goes through the charges, Lordship, there are serious charges, Lordship. As a in charge of the construction for constructing 60 mm explosive storage depot wall, Lordship, it was constructed with a cavity, Lordship. And there was poor drainage and layout, poor monitoring and all, Lordship, for which the DP was initiated, Lordship.
Fine.
Now, if your Lordship come to the representation which he submitted for setting aside the charge memo, Lordship, page 120, Lordship. He has not denied the charge. Only ground taken is that I joined in 2005 and the work was given to me in 2006. So I am a newcomer. It was a vast area. That is what he has stated. And he said that since 2 of the court of inquiry has been conducted already and the 3rd is waiting, so don't take action. That is the ground he has taken, Lordship. Page 120.
120.
120. Lordship may come to page 121, paragraph number 3.
Paragraph number?
3.
Yeah.
May I read, Lordship? The works mentioned at para 1 above were partially executed during my tenure at Garrison as Garrison Engineer Dehu Road. I was posted as Assistant Garrison Engineer Building Roads Project, hereinafter referred as AGBR under Garrison Engineer Dehu Road from so-and-so to so-and-so. It is my first appointment as Assistant Garrison Engineer and I had no previous MES works experience. I was just 25 years old and just 6 months service at that time, taking charge, subdivision and huge extensive scope of works having worth more than rupees 7,500 lakhs. As assistant garrison engineer, I had challenging responsibilities of handling such a mammoth contempt of work in such a difficult and scattered area spread over more than 20 kilometers distance. My tenure as assistant garrison engineer at Dehu was learning experience for me by my first works tenure under the probation period. Now, Lordship, if your Lordship come to paragraph 7 at page 122, the proceeding of the 3rd court of inquiry are yet to be completed. There is a strong possibility that the finding fresh at court of inquiry will point towards numerous errors, default in the initial planning, costing, technical sanction, various engineering drawing under action, direction and close monitoring of the contract during execution at the level of Chief Engineer Pune Zone and Commander Works Engineer. The same will put a question mark on the finding of initial court of inquiry. That's finding of the 1st and 2nd court of inquiry described above. Hence, disciplinary action against me at this stage is based upon the incomplete facts and not only are warranted but also against the principal. So he was asking for, since the 3rd court of inquiry is going on, don't take action against me. There is no denial of the charges. Rather, he admits that, in fact, for the work, he admits also, Lordship, the cost which was 212 crores has to be go up to 1,000 and something, Lordship. That he also he admits.
Not technically treated. डिले एक्सप्लेन किया है, डिले का ग्राउंड लेट पेज 145.
Lordship, may come to page 458, Lordship.
Mr. Chakraborty.
Lordship.
145, paragraph 93. Consider that with 122. जो paragraph 7 में बोला है कि मत करो मेरे लिए पर नतीजे आगे नहीं आए. We also know it is okay for the previous period. हाँ. No. हाँ. Because the process is different. It has to put no, this is not a process. It's an executive.
Yes.
Lordship, page 458, Lordship.
So, this,
What is it now? Ah, what better than that? You cannot get really English.
456, your Lordship will find that he admit that he was looking after the charge during the period of 2006 to 2009. Page 456, paragraph number 8. That planning, tendering.
455.
that's right. He may admit or he may not admit. If the tribunal has instructed
Okay, solely
on the ground of this
Delay.
delay, so you have to satisfy us that there was no delay. In fact, you have to satisfy us.
Lordship,
Maybe, what is your ground for that? It's not a case of delay.
Lordship, he admits that the work was completed in 2012.
Work was completed in 2012.
Then thereafter, 3 courts of inquiry. The last one is of 2014.
Work completed.
Lordship, everything has been explained in page number 14 of the writ petition. Page 14 of the writ petition. 14, Lordship. Paragraph number 9. The sequences, Lordship.
Yeah.
Lordship will find 2006 to 9 respondent service Dehu Road under Pune. 2011-12 lapses were noticed during scrutiny. Then in 2011, first court of inquiry. In 2012, the opinion of first court of inquiry submitted. Then there was 2013 second court of inquiry. Then there was 2014 the third court of inquiry. Then in 2017 we issued the show cause, Lordship. And 18 he submitted reply. Then on 12 to 18 we issued the charge memo. And 29-18 he submitted the written statement. 24/18, he submitted representation seeking dropping of the proceeding. Then he initially approached the Central Administrative Kolkata Bench Lordship. And 5/3/19, it was disposed of, directing to dispose of his representation. Then we disposed the representation, rejecting that on 27/19. Thereafter, he filed the OA Lordship. Now, whether solely on the ground of delay Lordship, that could have been quasi Lordship, I will to rely upon certain decision.
This first court of inquiry, for what reason this first court of inquiry and second court of inquiry?
Or to determine the lapses
Is
Lordship.
that reports of the opinion of the this
Lordship, I had submitted one of the court of inquiry, Lordship, fine. Lordship, opinion of the court, page 560,
560?
560. Opinion of the court. Then his name is at page 561, VK Gupta,
560.
560 letter.
This is the second court.
What is the affidavit date?
7/11/23. Filed by one Amit Das, Lordship.
No, this is 560, Vinod Kumar Gupta. Joint Director, Additional General Engineering Electricity. Amit Das,
Amit Das, Lordship.
that is page 583.
That is designation may be mistake. Lord. It's only 3-page affidavit and the court finding has said opinion of the court, Lordship. Okay. Name of various officers appeared, Lordship. And respondent name is at serial number 3. Paragraph number 3.
The name of the petitioner?
Respondent is VK Gupta. VK Gupta.
First photo.
This is first post of inquiry, then what about
Second and third, Lordship.
second and third?
That perhaps has not been annexed.
They have said that. There is a statement, there is a flag. Mr. Chakraborty, there was a statement made by you somewhere in one of the pleadings
Lordship.
that his proceedings are only confined to Court of Inquiry 1. Where is that?
There is another lordship, perhaps another affidavit filed in June 2023.
Also, इनका ये है।
This has also been filed by Amit Das lordship.
No.
इसका है। बहुत कौन सा? Yeah. Hmm. Issue में delay है तो it's here 13 to 15 13 to 18. Hmm. Second to wait, then third. Third can be the complete meaning. It's well, लेकिन सब record में एक भी नहीं है। नहीं अगर record को नहीं करते हैं तो क्या है मिल ले रहा है हम सब एडमिट मिला है ये डेट खाली जब दिसंबर 12 6 दिसंबर and ये 4/1/23 दौरान शॉप का नोटिस स्टेटस फाइनेंशियल रिसीव बाय द so this will be 13
Yes, no, Lordship has seen the allegations are very serious. So Lordship, solely whether on the ground of delay could have been caused or not, I am relying on certain decisions, Lordship.
Yes.
And also on the Lordship, the legal maxim, Lordship, nullum tempus occurrat rege, the lapse of time doesn't take away the rights of the crown, Lordship. Lordship, the first one is 2013 6 SCC, page 515. Anant R. Kulkarni, Lordship. The relevant paragraph is paragraph 8, Lordship. May I read, Lordship?
Yes.
The court tribunal should not generally set aside the departmental inquiry and pause the charges on the ground of delay in initiation of disciplinary proceeding. As such a power is beyond the limitation of judicial review. In the event that the court tribunal exercises such power, it exercises its power of judicial review at very threshold. Therefore, a charge sheet or so-called notice issued in the course of disciplinary proceeding cannot ordinarily be caused by court. The same principle is applicable in relation to there being a delay in conclusion of disciplinary proceeding. The facts and circumstances of the case in question must be carefully examined, taking into consideration the gravity and magnitude of the charges involved, Lordship. So that has to be seen. When the allegation is serious, Lordship.
But it may not be. Unpractical. Only on the ground of failure, on that.
Yes.
Next is 2009 15 SCC, Lordship. Page 537, B. Padmanabhan versus Government of AP. And the relevant paragraph is paragraph 13, Lordship. The second, the subpara of paragraph 13, Lordship, starting from the paragraph 13. Subpara that's starting from the appellant. The appellant, however,
Just. Paragraph 13.
Lordship, the subparagraph. They starting from the appellant. It's also grounded said that serious charges.
Lost. Oh, okay. Only by another dollar.
Yeah. Yeah.
Lordship.
No.
The appellant, however, filed the original application before the tribunal in India 1997. It was disposed of by the tribunal by judgment and order dated 2/1/2002. The state immediately filed a writ petition before the High Court, which was disposed of by an order dated so and so. It was during the pendency the matter before us. The appellant is said to have reached the age of superannuation. We therefore are of the view that delay alone in case of this nature should not have been held to be fatal in the matter of continuing departmental proceeding, as the charges against the appellant are serious in nature and the large sum of money have to be recovered from the appellant. It is thus not expedient in the interest of justice on the ground of delay alone, the matter should have been given acquitted. We may also place on record a reason based so and so, so and so. The Lordship. So when the charges are serious, Lordship, on the ground of delay may not be justified.
Yeah.
The next case is Lordship 1996 3 SCC, page 157. Secretary to Government Prohibition Access, Mrs. L. Srinivasan. And the relevant paragraph is paragraph 3.
This third judgment is secretary to the prohibition of excise.
Lordship. Relevant paragraph is paragraph 3, short judgment, Lordship. May I read, Lordship? Order dated so of the Tamil Nadu Administrative Tribunal, Madras is in question before us. The respondent, while working as Assistant Section Officer, Home, Prohibition Excise Department, had been placed under suspension. Departmental inquiry is in process. We are informed that charge sheet was laid for prosecution for the offence of embezzlement and fabrication of false record, etc., and that the offence and the trial of the case is pending. The tribunal has set aside the departmental inquiry and caused the charge on the ground of delay in initiation of disciplinary proceeding. In this nature of charges, it would take a long time to detect embezzlement and fabrication of false records, which should be done in a secrecy. It is not necessary to go into threshold. So, Lordship, when the aspect of monetary matter is embezzlement is concerned, Lordship, it takes time to detect.
Exact
Lordship.
charge of money is not there.
Not there, but Lordship,
negligence on the part of the exact charge of money.
charge in Lordship, instead of 60 mm wall thickness of wall, Lordship,
Oh,
is
there is the
constructed with a
allegation
cavity.
that he took money for that. or under the
Maybe
contract.
that is not the charge. I cannot argue on that point, Lordship.
That is that. And this judgment is of no. Sorry. Yes.
The other Lordship, 2017, 4 GLR, page 40.
GLP.
2017 4 GLR, page 40, Lordship. Equivalent citation is 2017 2 GLT, page 773. And the relevant paragraph is paragraph 52, Lordship. May I read, Lordship? Ordinary writ application does not lie against a charge sheet or a show cause notice for the reason that it does not give a rise to any cause of action. It does not amount to any adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction competence to do so. A writ lies when some right of party is infringed. In fact, a charge sheet does not infringe the right of a party. It is only when a final order imposing the punishment or other is adversely affecting the party is passed. It may have.
By referring to this judgment, show the Supreme Court judgment.
Lordship,
Reliance is placed.
Lordship.
Supreme Court judgment.
Lordship, that aspect has been built into the Lordship, 2006 12 SCC, page 28. Union of India versus Kuni Setti Satyanarayan, Lordship. The relevant paragraph is paragraph 13 and 14, Lordship.
Yes.
2012 11 SS.
Yes.
Paragraph 13 and 14. May I read? It is well settled by a series of decision of this court that ordinarily no writ lies against a charge sheet or a show cause notice, right? Executive engineer so and so versus so and so, special director and others so and so versus so and so.
Which one? We basically. Defense answer.
Yeah.
The reason why ordinary writ petition should not be entertained against a mere so-called notice or charge sheet is that at that stage, the writ petition may be held to be premature. A mere charge sheet or a so-called notice does not give rise to any cause of action because it does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction to do so. It is quite possible that even after considering the reply to the charge cause, show cause notice or after holding an inquiry, the authority concerned may drop the proceeding and or hold that the charges are not established. It is well settled that a writ lies when some right of any party is infringed. A mere show cause notice or charge sheet does not infringe the right of anyone. It is only. So, Lordship, in my humble submission, Lordship, the delay has been properly explained, and Lordship, on the ground of delay, the charge should not has been was Lordship. And Lordship, I'll be relying on the legal maxim, Lordship. Lapse of time does not take away the right of the crown, Lordship. That's
Lordship, page 200 and.
Mr. Cal.
First, I want to place page 220. The part of the tribunal's order. By charge it was caused. Paragraph 13.
Yes, sir.
Page 220.
Yeah.
Merit. Paragraph 13. The stand of the respondent authorities for initiation of proceeding in delay is the respondent's come to notice of the irregularity and lapses the part of the applicant during 2011-12. After his first promotion on October 2010, second promotion dated December 2015 was made to the applicant as there was no charge sheet issued and the charge sheet was issued based on finding of the staff court of inquiry conducted during period 2011-12 from the statement made by the respondent in paragraph 6 of the written statement. It is ample clear that the period, if any, allegation or lapses on the part of the respondent was between 23/5/2006 to 31/12/2009, and the authority was sitting with the matter up to 2011-12. That is more than 5 years. Noticeably, the applicant got his two promotion. Thus, it is explicitly clear that the proceeding initiated by the disciplinary authority after 12 years on 12/2/2018. If the authorities have any doubt or found any irregularities or lapses on the part of the applicant, which was the subject matter of the inquiry stated to be have taken place between 2006 and 2009, as aware in 2011-12, that too, no proceeding was initiated.
He was promoted, therefore,
Two occasions. Then let's see. That too, no proceeding was initiated and awarded till 2018.
what about the finding of this tribunal regarding charges?
Let's see.
Charges. What is the finding of the tribunal regarding charges? Charges are not serious or something else. Where is
It
that?
is not there. In paragraph 21 is the conclusion part.
In view of the discussion, foregoing paragraph ratio laid down by the Honorable High Court as well as the decision of Central Government, we are of the view disciplinary proceeding initiated not permissible under the law. How?
Some judgment has been quoted,
Only judgments have been quoted.
but that there is no finding to that effect.
That effect then?
Only delay part has been considered with the ground.
Can it be, sir?
And Lordship, on merit also, my learned friend is placed first court of inquiry. Lordship is pleased to see. My learned friend
The tribunal has read on a decision,
yes, sir.
this state of AP and VN Radhakrishnan 1998 4 SC Supreme Court. And they said, in considering whether the delay was vitiated disciplinary, the court has to consider the nature of charges, complexity and what occurred the delay occurred. If the delay unexplained prejudice, where is the charges discussion regarding the charges?
I think that probably that is not been.
Probably that is not been, then how you are justifying this case, sir?
But in paragraph 12, that has been quoted.
These have been quoted, so at least there must be some finding, no, these charges are not serious.
That finding is not good. But prime facie Lordship, my learned friend has placed first court of inquiry. But so pleased to see that. Then I filed my reply also. That is also on the record.
Court of inquiry is altogether different thing. See the charge, memorandum of charges.
No, Lordship, me pleased to see page 560. One affidavit filed by petitioner by one Amit Das.
Page
In my affidavit is 560.
560.
Lordship.
Yes.
I'm reading from the page 560. The court is of opinion that due to non-adherence of MES procedure in plug designing, contract formation, monitoring, etc., maintain of documents for proper and quality control, inadequate testing and supervision of the works under job number so and so. At deep road to conduct the defects in the above so and so. Now, paragraph 2, responsibility of Gs, responsibility of various Gs for different lapses during the tenure.
Where you are reading?
Probably there is some difference in pages.
Various Gs, yes, different lapses during the year, yeah.
The responsibility of various GSE, then Lieutenant Colonel Anand Shukla,
Yes.
he was the JE. He against him construction of bulk of load platform with incorrect high. The issue that J meter poor plug for area drainage, then C poor then poor quality of materials workmanship, then B Colonel Pramod Negi. Then next page C Piyush Gupta, the responsibility of AGs. I am the additional responsibility of various AGs for different lapses during the tenure. Gross negligence and poor supervision and construction of wall, so and so, so and so. Then 2, construction of work of loading platform with incorrect less than 1 meter. Poor quality. These are the 4 charges against me. No charges that any financial liability against me. That's it. Now,
That we have already pointed out.
then other some GAG is also pointed out.
What was this nature of construction?
So construction of explosive storage depot, Lordship.
Explosive storage.
60 meter with 60 mm thick wall. And that has to be fire ramp, drainage and all has to be done, Lordship. It says
Then thereafter 2 inquiries were held.
ESS, in short, it is called explosive storage house.
Construction of
Explosive storage house.
storage.
House.
ESH.
ESH. Okay.
Yes.
Well, Lordship, now I want to place affidavit filed by me. That is, it start from page 556.
Your affidavit.
Yes, sir.
Yes.
Second affidavit. It was filed on.
Yeah, it is there.
Section of-
19 July 2023.
No. Okay, page 557. Paragraph 3. That with regard to the statement made in paragraph number 1 of the additional affidavit, the deponent beg to state that the document includes as an extra act by the petitioner before the honorable court is totally irrelevant and misleading. It is pertinent to mention here that there were total 3 numbers of staff of inquiry held for investigating the role of the different officials on different period of time. The charge memorandum dated 12/12/2018 has been issued to the sole respondent, that is Vinod Kumar Gupta, Joint Director, and the basis of first court of inquiry only. The said charge memorandum has been satisfied and quashed by the learned Central University of Guwahati bench. Next page. The instant respondent is not involved in second and third court of inquiry. Therefore, no action has been taken by the military engineering service on the basis of second and third inquiry, sub court of inquiry. The document encloses an annexure acts by the petitioner before this honorable court is related to second staff court of inquiry. Therefore, these documents are totally irrelevant, misleading, and does not pertain to the instant petition. The covering letter of the charge memo dated 8 May 2018 clearly mentioned the name of the court of inquiry, which reproduced here and the staff court of inquiry to investigate incorrect construction of ammunition said not conforming to BRG and spaces at Aman Depot, Dehru Road. Whereas the document includes as an action act by the petitioner before this honorable court is related to second court of inquiry on the following subject. The staff court of inquiry in read over payment made to the two static water tank and storage of storage at Dehru Road, number 24. Copy of covering letter is annexed R4. Next page. That it is stated that the petitioner are trying to mislead the honorable court by mentioning the second and third court of inquiry, which are not relevant to this case. The petitioner are trying to justify a delay in issuance of the charge sheet to the sole respondent at the distance of 12 years since execution of the work. The detail of three stop inquiry and timeline of event been given is under the information of this honorable court. The timeline, the first is open inquiry, the staff court of inquiry to investigate incorrect construction. Administrator said not conforming to DRGs and spaces at Aman Deep Dehru Road, number 24. 1. May 2006 to December 2008, period of execution of work. January 2009, abandoned at the work site and left the work. 7 July 2011, first staff court of inquiry ordered. 4th May 2012, first staff court of inquiry completed and the report submitted. That has been placed before your lordship. 4th January 2013, proposed notice dated 6 December 2000 issued by the respondent. Then next 13 January 2013, necessary document asked by the respondent to prepare his defense. 3rd April 2030, petitioner denied the document to the respondent. April 2013, the respondent submitted his reply to so-called notice even after denial of document by the petitioner. 8th May 2018, respondent received charge memo dated 12. And lordship, and relying on two judgment that is relied by the tribunal also. The first judgment at our High Court. That is reported in 2016, 2016 code GLR, page 114. Paragraph 11 onward. This judgment is also relied by the honorable tribunal. Paragraph 11, narrative.
Yeah, paragraph.
11, 12, 13,
Page 5.
14.
Yeah, read.
As regard the first point, on inordinate delay, unexplained delay, a apex court in Catana decision have in no uncertain words held that it would be unfair to permit the departmental proceeding to proceed further at the late stage or at the distance of time. It would be prejudicial to the parties concerned. In the instant case, on the alleged irregularity against common party pertaining to period April 2002 to February 2003, the memorandum of charge issued on 5/3/2014, 7/6/2014, that is at the distance of 12 years. The only explanation rendered by the petitioner that since the initiation of the defendant proceeding is very serious exercise of involves care-based examination of the materials available. As such, care has to be taken to ensure that an innocent is not subject to this. Then what's it, another judgment passed by the Honorable Supreme Court. It is reported in 1998 4 SCC page 154. The name of the party is State of Andhra Pradesh versus N. Radhakrishnan.
1990.
1998 4 SCC page 154.
One five four.
154.
Yeah.
Okay, paragraph 19 only. And if another judgment is, motive is relied in one of the case last week, I was arguing that income tax matter. That state of Madhya Pradesh is promising. And this is judgment passed by your lottery.
Yes, please. It's a input from 1998. Paragraph 19. Gravity of the focus.
Yes.
And lottery, this is the latest judgment passed by your lottery. In case of where there was a delay of 8 years and where there was a enjoyment of 120 crores, there was allegation against the petitioner in case of the income tax officer. But here there is no allegation of any corruption.
Clear allegation in that case, yes, you started the inquiry after the order of the ITAT.
Yes.
That ITAT order was set aside or reversed by the High Court. Matter was again referred to the ITAT. ITAT is again referred to the assistant officer. That charge was diluted there.
No, let's see what happened in this case. Let's see, there was a allegation of allowing 120 crores.
That was on the basis of the finding of the ITAT.
No, look, that was the allegation against the petitioner in charge.
Allegation on the basis of this,
Charge will
since
frame.
that ITAT has your, whatever the decision, ITAT has reversed your decision, whereby you have granted this benefit of or what they allow this allowance of
Yes,
120 crore
crores.
something.
Yes, sir.
That was the allegation that your finding in the appeal, which you have decided the appeal, your judgment in the appeal was reversed by the ITAT.
Yes, that is the fact.
Then High Court has reversed that finding of the ITAT and remanded the matter to the ITAT.
Yes.
ITAT again remanded to the
AO.
assessing officer.
It's not.
So that
No, that's-
charge, that was diluted.
No, that was diluted, but that charge against the incumbent was that he did all this misconduct. So here, Lordship, here the charge is that, and there are 4 officers above him. And main charges against them, and Lordship in inquiries 2 and 3, there is no charge against me.
Yes.
So this is the fact, Lordship. Under the second Lordship, the tribunal has not committed any irregularity or rightly passed the order. Lordship. In my affidavit, first affidavit, Lordship, when I was due for next promotion, the charges were issued to block my promotion.
That's all.
No.
Sure.
My affidavit, 2 affidavits, my kindly.
Order is reserved.
Oblige you.
We'll see. Yes.
Item 16.
May I please, Your Lordship. Lordship, this PIL has been preferred by the petitioner, my lord.
What happened to that complex? That
Lordship, that
commercial shopping
commercial
complex
shopping complex has been constructed by the
constructed.
Lordship.
I thought we did.
My lord, at the time of filing, they have just
That's-
started, but
Now that is operational.
now that is operational.
Operational. Then what next?
My lord, there remains that is, my lord, in that case, my lord, what happened, they have given a proposed, means new a drawing in their affidavit in opposition, in which they have shown that the ground they have kept for parking. And they have shown it as a reserved parking. Why they have reserved it, I do not know.
Reserve it for the customers who are visiting the shopping complex.
But they have demolished the lordship, the waiting shed of the commuters.
What do you want?
the
Demolish this shopping complex or what?
This is not the commuters of shopping complex, but the commuters must do those the passengers for this setting, waiting shed, they have demolished them at the time of constructing this building.
And now,
So, my lord, there is no place for the commuters to stand, my lord. There you have to stand in the rain and sun, my lord. That, my lord, that at least, my lord, this reserved parking, some part they should have given for the commuters. Parking, my lord, this is a public, my lord, bus stand, my lord. Public bus stand. How can
shopping
they, my lord?
complex of a parking, the parking of a shopping complex be given to the commuters? bus stand.
Bus stand, my lord, because this has been constructed inside the bus stand, my lord. By demolishing the, my lord, waiting shed of the bus stand, my lord. And that too, my lord, they have constructed it, my lord, without any authority. The land also does not belong to them.
Now they've constructed, the land belongs to whom?
Land belongs to government, my lord.
The government will raise objection. Who are you to raise this objection?
My lord, this bus stand is running for last more than 50 years, my lord.
And now
And
the
my lord,
shopping
this one
complex
has
is, now the shopping complex is operational.
shopping complex is operational.
This melody is completed, madam. Only waiting for the inauguration, madam.
So they are waiting for you. Mr. Sharma will inaugurate.
No, my friend.
Okay, you go and inaugurate. Say it.
It has already been completed.
Some matlab, for this, matlab, isn't there some protection so that matlab, they can matlab, this some part of that matlab, ground floor that is made for parking should be given for there as a waiting shed, my lord, at least.
How can they miss it?
Because they are claiming that this meaning,
Shopping complex,
this
if the shopping complex is there, the customers.
shopping complex means matlab,
They
only
also need some, otherwise they'll
the five
park,
stops.
otherwise they'll park their vehicle on the roads and all, again it may create a chaos.
My lord,
My lord,
for
it has
private
created
vehicles,
a
my lord, this
dumping
is
ground for the, my lord, abandoned vehicle of the, my lord, bus owners. That has been the situation earlier, my lord.
this is.
They want to park the abandoned bikes in the bus stand.
Well, five shops have been constructed in the first floor, and for five in the ground floor,
Who
they
is
have
the
located.
petitioner?
My lord,
Who is the petitioner?
petitioner is one, my lord, Nikhil Hus.
What he is doing?
My lord, he is an agriculturist, my lord, by profession, my lord.
Agriculturist by profession.
My lord,
Which village?
my lord is a village,
Permanent resident of Kendugri,
Kenduguri. It is around
district Tinsukia, Assam.
Tinsukia, Assam.
And he is raising this concern about construction of
Big boy.
This my lord, commercial shopping complex inside the bus stand, my lord.
And no one from that area, my lord, raised any allegation against, my lord, construction of this.
And you are raising this objection regarding Digboy town. How far Digboy is from this your village?
Around 10 to 15 kilometers.
Okay.
He is also using
So
the
you are
same.
traveling by bus only?
My lord, he is traveling by buses.
Traveling
my lord, here and
bus
there,
or
because
having
this
a
is the
own car or what is this?
only bus stand in Tinsukia, my lord, Digboy town, and he is using the bus stand, my lord.
First time.
My lord.
Still,
Already done.
Like they have constructed about a gas pipeline that has been digged when they have digged for post. And they are on by of the gas taker, this gas persons have come and they have diverted the line. These things have also happened, my lord. They have not obtained any permission from any authority to construct it.
अभी बोला है कि सर ये होने के बाद विकास मैं रुकूंगा due to demolition, the building services are not taken. Not very intention. They would have made the ground floor of this waiting shed and this would have shown the reserve parking for person. But they have shown it as a reserve parking for 40%. And वो जगह मिलने से फिर से question it was we think it is very seems to be 3-1.
So far, my lord, the allegations, my lord, regarding my lord, waiting space is concerned. Lordship may kindly see the resolution of the board at page 105. And my lord, relevant person at 106, resolution number 2. Yes. After prolonged discussion between all the board's members present in the meeting, it was decided that as the existing waiting shed at a public bus stand at present is very small and inadequate to accommodate large number of passengers also. It is devastating condition at present. Hence, the old waiting shed should be demolished and a new and spacious waiting shed should be constructed in the vacant place at eastern side of the bus stand as soon as possible. They have already taken this decision. What remains?
This is of my lord, July 23, my lord, this resolution. But they have constructed the whole building, but they have not constructed the shed,
We'll see.
my lord.
Click here, this PA
People are,
petition is filed.
public is suffering, my lord.
This PA petition, where is the public? Public is not before us, only individual is before us.
He is representing the
This
public.
PL petition is filed by the petitioner opposing the construction of RCC commercial shopping complex within the Digboi public bus stand Digboi. Stop. It is informed that the construction of the RCC commercial shopping complex within the Digboi public bus stand Digboi has already been completed. Stop. Learned counsel for the petitioner has submitted that before construction of the said RCC complex, one waiting shed, one waiting shed for the passengers was there in the, at the bus stand, but the same has now been demolished, and therefore the people at large are facing problem since there is no place for the commuters to wait for the buses. Full stop. Learned counsel appearing for the respondent state, Mr. Sharma, has invited our attention towards the resolution of the Digboi Municipal Board, Digboi, dated 17th of July 2023, resolution number 2 in the dated 17th of July 2023, wherein the board members, after prolonged discussion, has decided to demolish the existing waiting shed at the public bus stand since it was very small and inadequate to accommodate large number of passengers, and has decided to construct a new spacious waiting shed in the vacant place as the eastern side of the bus stand as soon as possible. Full stop. In view of the fact that the construction of the RCC complex has already been completed and the municipal board Digboi has already passed the resolution for constructing a new spacious waiting shed at the eastern side, at eastern side of the Digboi bus stand. We don't find, we are of the view that no further order is required to be passed in this PIL petition. The same is therefore dismissed. Applies.
Pass over meter 25 for orders.
So it is there.
Yes, madam.
This contempt petition is filed on behalf of the petitioners complaining that the respondents have not complied with the directions given by the division bench of this court in the judgment dated 10/7/2017, passed in writ appeal number 304 of 2014. Stop. The white judgment dated 10/7/2018. The division bench has allowed the writ appeal preferred on behalf of the appellants and has directed the state respondent to take back the appellants into the service of assistant teachers in their respective schools by passing necessary order. It is further observed that the appellants are not entitled for the back wages. However, the period without duty spent by the appellant shall be treated shall not be treated as break in service, and the said period shall count for the purpose of service benefits, including retirement benefits. Good stop. The order passed by the aforesaid order has not been complied with by the respondents despite granting several opportunities. Ultimately, on 6/11/2024, the contemners were asked to remain present before this court. The respondent number 1 appeared before the court. However, the respondent number 2 didn't appear on as she was on leave. Full stop. Respondent number 1 has assured this court for compliance of the order passed by this court, and pursuant to that, an affidavit is filed on behalf of the respondent number 1, wherein the copy of the order dated 6/11/2024 is produced on record. In the affidavit, the respondent number 1 has also sought has also offered unconditional and unequivocal apology from this court. Full stop. The order dated 6/11/2024 passed by the respondent number 1 is reproduced here under. It's page number 43. Having gone through the order dated 6/11/2024, we are of the view that the order passed by the order passed by this court on 10/7/2018 and so has substantially been complied with. Hence, no further order required to be passed in this contempt petition. The same is disposed of, notice is discharged. Yes. This, in this Hill appeal, who is appearing in this Hill appeal?
The last occasion, your lordship told me to examine this matter, whether he'll appeal, will appeal. But I have examined this matter, and it appears to me there is a High Court rule. Assam High Court jurisdiction over the District Council orders 1954. And as per this rule, there are two provisions. One is order 3 and other is order 6. 3 papers for appeal and order 6 papers for revision. And my lord, there are a number of judgments have been delivered. There is no such part and first rule that it must be placed before the division bench or it must be placed before the single bench. Sometimes single bench takes up this matter, sometimes division bench.
We have already registered it as a Hill appeal.
All right, no problem.
Then
Then your lordship may kindly fix a date and please, yes?
what about the trial court's record is not there?
No. It will be done there. Report to culpable ability.
We'll call for the record. From the LCR, we'll call for the. I think to record the.
Yes. But they have obtained certified copy from the LCR when LCR has been come before the court. And that they have annexed with their memo of appeal. LCR already received by the Honorable Guwahati High Court. And they have obtained certified copy from the LCR.
All records are not available, mate, in our appeal. Memo appeal, they go to assembly, I got it. Upon the certified copy. Certified copy, like you. In the could not like LCR, say, can I to certified copy? Oh, you take your one and I'm like,
Okay, we'll ask them to take the record and then we'll list it. When to be listed?
On 19, my lord, or 21st.
19th or 21st?
19 or 21st.
It will take some time. We'll fix it in January. Any date in the January. Second week of January. Second week. Yes.
Leave the matter with LCR, my lord.
Yeah.
LCR, my lord, with the LCR.
Yeah, with the LCR. That's why
Yes.
only we thought that. Without LCR, what we'll do?
Yes.
With the LCR on.
Second week.
Is any other matter? This 18, 21, 23 and 24?
Bola.
Where for 21, man? Number 3. Well, 18.
18.
18.
Item 18.
What do you do? You're into 18 months.
Yes.
May I please, Lordship? Lordship, in this matter, my grievance is that the wrong
matter?
fixation. Item number 18, my lord.
Yeah.
My lord, the wrong fixation of pay has been done in my case.
We will hear after some time. We have enough judgments to deliver.
My lord,
We'll have these matters after some time.
my lord. Bless the Lord.
We have reserved enough number of judgments. We have to deliver those judgments also. That's why. Thursday, go to
1 and 2,
14. 14th को देते, ठीक है.
14.
1 and 2.
Please talk about.
12.
12.
Yes.
Item number 1 to 4.
My lord, here that OA number 311 has been challenged by writ petition number 1669, my lord.
What happened in that?
That is, my lord, also in the same consequence, my lord, that is as per that order. My lord, this is the order of. Considering the covert method that has been disposed of, my lord, same manner, my lord. My lord, that is.
What remains?
My lord, my submission is that is not a similar to that matter, my lord. That is that writ petition number 1674, my lord. The fact of 1674 is different from that when that is listed matter, my lord.
Original. Original rate that So now you are saying that with the seventh pay commission, this rent-free accommodation has been discontinued.
Yes, ma'am.
But here, the rent-free accommodation for which, for the year 2011 to 13, they have, this, tribunal has ordered that no recovery shall be made. 2017, it's okay,
Yes, ma'am.
but it's prior to that, then
And the period is, my lord, from my lord, here, my lord, yeah, that rent fee accommodation is, my lord, they are not entitled to the rent fee accommodation as per the memorandum, my lord, that is in page number 94 of the item number 1, my lord,
94.
94.
Read
My lord, that is OM dated 2/3/1960, my lord.
94 in item number.
Item number 1, my lord, that is Boshum, petition number, my lord, 1035. Review number 66. Yes, 37.
37 is this. 50. Yes, which OM number you are? Page number
I'm
94.
referring OM number, page number 94, OM dated 2/3.
94 in review petition. And review petition, there is no 94, it's only up to 37.
No, it is a copy to the light.
94 हमारा बताओ, it is there in our.
Yes, sir. May I check, my lord?
Twenty-four of this. Petition number 1036. 1035, compared to. Is it better? Repetition period. Into this. নাই না করবো কোথেকে তুমি এটা গন্ডগোল হয়েছে। This, in case of this, Biju Basur Matri,
Yes, ma'am.
what is your stand before the tribunal?
My lord, before the tribunal, my lord.
Whether you have filed any reply to the OA?
Yes, my lord.
Where is that?
My lord, in the Biju Basra case, my lord, page number. Biju Basra. My lord, our stand is paragraph number 6, my lord. Last para of this page number 94, my lord. They are not entitled as per OM dated 1960, my lord.
What is your specific stand before the?
Our stand is as per 1960 OM, my lord, they are not entitled for rent-free accommodation, my lord.
Why?
My lord, rent-free accommodation as per their nature of the work, my lord, they are not.
Where is that, sir? Where is that? You have mentioned it. Now you are taking this stand that they are not entitled. Why? They are not discharging the duties of so and so. Where is that? Where is that stand?
My lord, before OA, my lord, before that, my lord.
Actually,
Yes,
where is
my lord.
that? Where is your reply to the OA?
Yes, my
Any specific stand that these are the persons who are, they are Hindi teachers and they are not
entitled for
this having difficult authorities or whatever it may be. Where is your reply to the OA?
Yes, ma'am. My lord, reply, I didn't annex the reply, my lord. I'll file that, I'll bring that affidavit.
How many times you'll say, simply said again, not applicable, why not applicable? Where is that?
My lord, in paragraph 9, my lord. Paragraph 9 of of Visubotan will get, my lord, paragraph 9, paragraph 8, my lord.
Yeah.
Paragraph 8, my lord, at the outset of the argument, HC or learned counsel if on behalf of applicant submit that in the last para, my lord.
Paragraph 8.
Paragraph 8, my lord.
Yeah.
The competent personnel are entitled to rent fee acquisition by the virtue of that is their stand, my lord. Our again. My lord, I will be allowed to file additional application to bring that, my lord, bring that written statement filed before that, before the gap, my lord. Paragraph 18, my lord, that is regarding the nature of the work, but that is the submission of applicant, my lord, not our submission, my lord. Paragraph 8, my lord, there is the competent personnel entitled to rent fee by virtue of nature of their duties round.
Just see to it. Now this Guwahati High Court has already observed
Yes, ma'am.
that despite this 1960 order, which says 1960 on which you are placing reliance, this page number 95.
Yes, ma'am.
Honorable High Court has further paragraph number 13 is that on a query made by us, nothing could be submitted on behalf of the respondent to show that the letter dated aforesaid has been decided, cancelled or revoked, withdrawn or superseded by any subsequent letter issued by the Ministry of Government of India. Consequently, so long as no exercise in terms of decision, which is the Ministry of Housing Affairs so and so, is carried out by the Ministry of Home Affairs, Government of India, petitioners cannot be deprived of rent-free accommodation or accommodation at the reduced rate as the case may be. As this aspect of the matter needs re-examination and the required determination of disputed question of it is the learned tribunal which we find to appropriate for these shall be determined.
Yes, ma'am.
Now, this was remanded.
Yes. This was remanded, my lord, yes.
From the perusal of the contents of the so and so issued by the Housing Department, which was earlier produced before the tribunal, as well, it is brought to my notice that the Ministry of Exchequer are requested to review the rent concession already allowed to the government survey, so and so. On a query made by Mr. Vora as to whether letter dated issued by the Government of India has been cancelled, decided, withdrawn, subsequent issued by the government of India and failed to make any submission to the query. But the respondent council also failed to make any submission. As to the query, government of India has reviewed the rent concession already allowed to the government servant, Ministry of Affairs and subordinate term in consultation with the Associated Finance. Either any reply or any material placed before me by the respondent council to control what the submission as to the continuity of the letter dated and to buttress the submission, Barua placed before me the complete so and so. However, no such controverting argument is that of the respondent side. That being the position after taking into the entire conceptual of the, I am of the view that justice would be met if the respondent authority is directed to take a decision to approves the rent concession as appellant so and so issued by the government of India. Accordingly, I direct the respondent to take a decision of the rent concession already allowed to the government servant, ministry, official attached and subordinate to them in consultation with the so and so till the decision is made. No recovery of license shall be made. This is what the order is.
Yes, my lord.
So,
My lord, the review petition has been filed on the ground that has been decided in the light of 1647, my lord.
how it makes a difference, ma'am?
But
1647 says what?
1647, my lord, that is regarding, my lord, allotment of type 3 accommodation, my lord.
One 1647 or 476?
1674, my lord, sorry.
1674?
1674, my lord.
No, it was decided in writ petition passed in 4761 of 2016.
Yes, my lord, 4761, my lord, but this was, yes, my writ petition is, yes, my lord, but writ appeal, my lord. Writ petition was decided on, my lord, where that is, but no, so, no, my lord, kindly see. Yes, my lord. That writ petition has been disposed of in the light of writ petition number 4761, my lord.
4761,
Yes, sir.
what it says?
4761 says, my lord. Yes, my lord. 4761 is, my lord, different. That is, my lord, regarding that allotment of type 3 accommodation, my lord, between 2011 to 2013, my lord.
Cannot be recovered from the applicant.
Yes, but that is regarding house rent allowance, HRA, my lord.
Recovered, funded.
They could not produce that certificate, my lord. That is different. The fact is different for 4761.
At that time, who appeared for the respondents?
For the respondents, my lord, appeared as per court order, my lord, Architect was appeared, my lord. As
For the this applicants,
applicants, my lord,
SCKL,
SCKL, my lord.
Sonowal, Mr. S. Sonowal,
Yes, ma'am.
Azam Siddiqui, another. S. Sonowal. Issue notice returnable 8 weeks. Registered AD and the state. Yes,
Master.
all these.
Yes,